think what's striking is how much actually the defendant and the claimant solicitors have to say to each other. They both just want the system to work.
I think the discussion really highlighted where we've got to in terms of access to justice, and I think that the general consensus was that it's very difficult for claimants now. It's a very, very different landscape, it's a different framework, and there are consistent and constant challenges.
What strikes me is that LASPO is universally unpopular amongst the claimant sector, but actually the claimant sector has found a way to manage and to sort of thrive in some ways, in spite of the constant kickings that it seems to receive from ministers.
You always worry about this, the way reforms are coming in, that this is going to slowly erode into access to justice. So I think the industry is actually adapting to it and finding ways to work with the clients and making sure that the justice goes on.
LASPO definitely did what the government intended. It reduced the numbers of claims going through the courts and reduced cost, but it certainly also reduced access to justice.
There is a lot of agreement between all the parties within the sector about things that are not working well. So there were a lot of concern about complexity in the system, the way that the costs rules work, and there was not the usual entrenched positions between claimant and defendant lawyers, which you do sometimes get in these sorts of discussions.
And there's this juddering disconnect between what policymakers think the features of this market are and this section of the law is, and what the practitioners say. And actually, if it was left up to people in this room, the system would be working a lot better.